Good afternoon. My name is David Whitney, and I'd like to warmly welcome you to what I hope is the first of a number of FRA webinars which are going to look at OFR and specific supervisory and regulatory issues for sole practitioners and small firms. We thought it would be helpful to have a brief introduction, so I'll give you a little bit of my background and then hand you over to Sakitra Hammond. So I'm a solicitor with 15 or 16 years of post-qualification experience, but I started my legal career as a student in a placement at a sole practitioners in Birmingham. That gave me an insight into the kind of work and operation of a small practice. Since then, I've worked in a number of other firms. I've specialised in litigation to do with professionals, disciplinary matters. I've given consultation and training to a range of firms on professional standard issues, worked as a risk manager in a medium-sized firm, and now I find myself here at the FRA. Sakitra, what about you?
Good afternoon, everyone. I'm also a solicitor and worked in private practice until 2003, when I joined the Practice Standards Unit as an advisor. I did that for about 3 years and looked at a variety of firms during that period, small firms, sole practitioners, through to big city firms. And I then went on to become a regional manager, which I did for a further 3 years. And at the beginning of this year, I moved into the Regulation Directorate, and I am the co-author of the April consultation paper on outcome-focused regulation. And since July of this year, I have been working on the relationship management pilot and its implementation. So that's me, David.
One or two or three members of our team are not actually on the broadcast today, but they come from a range of other backgrounds and experiences. Solicitors, accountants with experience in practice, in supervision and regulation, some forensic skills. Between us, we feel we have a very wide range of experience and knowledge of law firms, and we think that's going to be of considerable benefit as we roll out relationship management. Anyway, enough of the background and who we are. What I thought I'd do is just give you a little bit of a heads up on what we propose to do this afternoon. Sakitra and I are going to give a 20-minute or 25-minute perhaps presentation on the key issues around relationship management, and then we will throw open the floor for questions and answers. So some of those questions we'll take from your emails. We hope there'll be some oral questions as well. Before we get there, we may actually give you a few questions partway through the presentation, 2 or 3 polling questions just to see where you stand on 1 or 2 topical issues. So that's the general shape of things for this afternoon, and I think, Sakitra, you're going to have a look at what the key questions are going to be.
Indeed, David, thank you. You can see we want to focus our webinar on the 4 key questions that you can see on your screen now. What is relationship management and why are we trialling it? What do we hope to discover from the pilot? How does risk fit in, and how will relationship management work after that pilot? I'd like to start by putting relationship management into some context and giving you some background. The Legal Services Act, as many of you will know, brings about the dawn of alternative business structures. And all going to plan, they should come into our horizon on the 6th of October 2011. We'll see a more flexible approach to both ownership and control of legal services providers, allowing both lawyer and non-lawyer ownership of legal entities. To ensure that we have a regulatory framework that can effectively regulate our changing legal landscape, we are also introducing outcome-focused regulation, or OFR. And basically, that approach aims to remove the detailed prescription of rule-based regulation by replacing it with high-level principles and outcomes, in turn giving firms the freedom to achieve the best outcomes for clients in a flexible way. We're calling that initiative Freedom in Practice. And to date, we've issued 3 consultation papers, 1 on outcome-focused regulation, the first one on the handbook, and we have a current consultation paper on the handbook open, which remains open until the 13th of January 2011. Now, many people have responded to the two consultation papers on OFR and the first one on the handbook, and that is gratefully received, so I would urge you to read and respond, because your feedback is most valuable to us. So what does all of this mean for you? We recognise that in order to implement the changes we want to move to outcome-focused regulation, we have to change the way in which we engage with those that we regulate, as one size does not fit all. We recognise, therefore, that we've got to have a greater suite of tools to be able to use when we supervise firms. We also need to change the way that we relate to firms, and the relationship that we have with them should be one that is based on trust and understanding. And when I first became a practice standards advisor, I went to see a firm, which is a two-partner firm based in London, who, in the opening meeting, I explained the purpose of the visit, the role of the advisor, and what the aim of the visit was. And the partners nodded and politely accepted what I said, and at the end of the opening meeting, I asked them if they had any questions, and one of them turned to me and said, "But why are you really here?" And they had clearly not accepted what I'd said, and it showed me really that there wasn't this level of understanding or trust there, and that isn't something that we can carry on with, and we're very mindful of that and want to change the way in which we regulate and interact with firms. And I'm going to pass you over to David, and David's going to talk to you a bit more about the role of supervision and relationship management.
Thanks, Sakitra. I'd just like to pick up on a couple of points that I think Sakitra's just mentioned, and that's in the context of what is relationship management and why are we trialling it. As Sakitra, I think, has indicated, we're not really satisfied that the current form of supervision is fit for purpose. And so we're using the current period of transformation in regulation to trial a new form of supervision. And in doing so, we want to think, how can we improve supervision? How can we make it more targeted and more effective? We have 10 or 11,000 firms to supervise, and clearly we need to have differing tools to manage to supervise right across that piece. What we want to do is be more proactive, as I think I've just said, and by that I mean that we want to try to prevent regulatory risks from crystallising. So one of the approaches to supervision is relationship management, and by that I mean a dedicated form of supervision. We're looking at having particular teams of people who will work closely with firms in order to deal with particular risks. And we will supervision generally, of course, is the risk-based oversight of the whole profession, and we will use risk as the driver to consider where to apply our supervisory resources. The aim of the supervision is to help firms improve their standards, to reduce risks for clients and enhance the reputation of the legal profession. That's all what we're all interested in at the end of the day. Anyway, what I'd like to do is to move on to the 4 questions that are driving our pilot. These hypothetical questions are the things that we are already asking, and we will test the success of the pilot against these in July. So, is it ever proportionate to use dedicated teams of relationship managers in supervision? Well, we think that the answer may be yes, but we will want to see that the likelihood of risk in a particular firm is high, or that even if a particular risk is not likely, the impact of it, if it were to occur, would be very significant. And in those circumstances, we think it might be proportionate to use a dedicated team to proactively go in and try to help a firm manage away or mitigate the risks it faces. So those, I think, are the working assumptions there. And there are some other advantages of using a a relationship management approach as well. I think it's fair to say, going back to the one-size-fits-all criticism we've faced, that in some ways we have not always understood particular specialist or expert firms as well as we might have. And what we'd like to do is to use relationship management as a means of understanding particular types or shapes of firms, niche firms that maybe before we've not really engaged with properly. So that is another aim of the pilot. And what we will do at the end of the pilot is to gauge just how high a risk, whether it be by likelihood or by impact, will be required for relationship management teams to be used as the main form of supervision for a particular firm. Probably enough of the theory there. Maybe you could pick up on how does risk fit in, Sakitra?
Thank you, David. Many of you will already know what we do currently with risk, which is to look at the Solicitors Code of Conduct. We look at the rules and we say if one of those is breached, we give it a risk rating. You can see an example of the ranking of risk under the current code on our website. Essentially, we are waiting for a risk to crystallise, and then we apply the most appropriate resource to that. We do, of course, do some proactive work, but we recognise that we could do much more of that. We also recognise that our current approach is too reactive, and it can be very costly and time-consuming in going in to sort out issues once the problems have occurred. So we have to get better at assessing risk and taking a more proactive approach to preventing the risks from occurring in the first place. This isn't an easy task, and we have a specialist team in place looking at developing the risk centre and our risk work, which is going to sit at the heart of everything that we do. Now, in order to do this, we need to take a more 3D look at the risk assessment, taking into account factors such as economic environment and the impact that that might have on firms generally, but also more market-specific information. So is there anything that will affect certain sectors of the profession? And crucially, information from the firms that we actually regulate in order to better understand those firms and the risks that they have within them. But we are also mindful that in gathering information from firms, that there is also a moral hazard of collecting information that we can't use, and we're engaging with stakeholders to understand the issues of gathering data. There is no benefit to collecting information that we can't either process or use, and we are very mindful of that. But we do understand that our risk assessment has to get much better. And I'm going to pass you over to David, who's going to look at how risk assessment will actually drive our supervisory activities.
Okay, thank you, Sakitra. As you can see from the slide, I'd like to talk to you a little bit about three specific types of risk. Risk to the SRA's regulatory objectives, risks that firms will not act consistently with the overarching regulatory principles, and risks that firms don't comply with outcomes. How does that all fit together? Well, some of you may have seen that at the start of the Legal Services Act, the regulatory objectives that the SRA are working to are set out. I won't read all 8 out to you, but 3 of those I think set the sort of picture of the framework we're working in. We have to protect and promote the interests of consumers. We have to encourage an independent, strong and diverse and effective legal profession, and we have to promote and maintain adherence to professional principles. Those are 3 of the 8 regulatory objectives we face. We are, in turn, have used those to shape the overarching principles that now find their place at the start of the new draft code, all 10 of those, and also the outcomes that underlie them. So how does that all fit together? Well, let's take an example. We are interested in ensuring that firms are financially stable. That is part of the objective to ensure an independent, strong and effective legal profession, of course. How does that interact with what you will see on the ground? Well, if we relationship manage a firm, we would want to come in and understand the risks in a particular firm around whether funding and finance is stable and secure. Are you confident of that? Does a particular firm or practitioner take a prudent approach to financial risks? And are there sensible controls and procedures in place in connection with financial matters? That's, in a way, how these issues will interconnect. We will use the risk centre, as Solicitors has said, to drive a lot of our work and our profiling of firms, but we also need firms themselves to take ownership of risk. And the idea that we have come up with is that firms will produce their own risk registers in which they identify the risks which they consider are the greatest concern to their business. I'm going to come back to that in a few minutes and hopefully give you a little bit more detail. But to give you a bit of a break from our voices, we thought we would move to some poll questions to see where you are at the moment on one or two issues. So, as you can see, the first question, does your firm regularly identify and prioritise the business and regulatory risks it faces? In other words, do you rank the risks you face and take action in accordance with that ranking? So, if you'd like to participate in the poll, and we very much encourage you to do so, please click on the yes or no and we'll see where we get to. Hopefully you can see the figures yourselves on the screen, and obviously the overwhelming majority at the moment say that they do regularly identify and prioritise the risks they face, which I find very encouraging.
That's excellent. We can see the results are still coming in, but they are very strongly in that yes category, and that is very reassuring from our perspective. And we hope that actually firms find that a very useful tool in understanding where their businesses are and where they're going.
Okay, well it looks like a lot of you have voted. Perhaps we should move on to the next question, which is actually appears on the slides. If we could move to that.
There we go. Whilst we won't have the kind of immediate satisfaction of seeing your responses, we think this is a very important question and may make you think about the issues within your firms, but could also help you look at what other firms are identifying within your sector. So what we're asking you is, what are the top 10 risks currently facing your firms? If we have sufficient responses, we will aggregate the risk types and circulate those to the participants of the webinar after today. We'd be really grateful to hear from you, and it would help firms within your sector to understand perhaps what are the key themes arising across the piece. So we hope to hear back from you on that. We can move on, David, perhaps to our third polling question?
Yeah, I think that would be good. Okay, so do you document the way that you monitor, manage and mitigate the business and regulatory risks which your firm faces? I guess what we're trying to do here is we're interested in promoting better risk management as a key part of the new changes, and we want to track and understand what firms do. We want to identify best practice. So if you actually, most of you said that you look at risk, but do you go to the next stage? It's looking as though the balance is probably in the other direction this time, so maybe slightly more firms are not quite as far forward with the documentation, monitoring and managing than we might have expected from the answers to the first question. Just out of interest, we spoke to some very large firms a few weeks ago, and only 50% of the very large firms use risk registers at the moment. So there's learning and improvement for all of us, I think. A lot of people have voted, so I think that's a helpful indication. Shall we move on?
Yes, that was very helpful for me, and I hope that will stimulate some debate and discussions at your firms. Moving on back to the slides, we can look at the pilot itself and what it involves. We want to work with a wide range of firms. The profession is so diverse, and we want to make sure that in testing the hypothesis that David has already set out about using relationship management as a dedicated form of supervision, and whether it's ever proportionate and effective use of our resources, that we test that against as many different types of firms as we possibly can. And in order to do that, we're looking at a range of firms across the piece, but we're only being able to pick something like 15 to 18 firms in the pilot. And you can cut and slice the profession in many different ways, and we're hoping to tick as many of those boxes as we possibly can. We've had an excellent response rate to people wanting to be in the pilot, so we have a large pot to choose from, and we're looking at a range of firms that will encompass the end of the market, that's the city, corporate, large, that end of the market, right down to the small sole practitioners, small firms, taking on board what David said earlier, niche firms, and, for example, BME firms, firms that are regionally, geographically spread out so that we're catching those issues that sit with perhaps more rural firms. As you can see, we've got our work cut out for us in choosing that spectrum of firms in the 15 to 18 firms. We have launched the first wave of the pilot with 6 firms, and they included a global firm, but also included the smaller end, a sole practitioner. We also had in there a BME 7-partner firm based in the Midlands. So we are beginning to capture the range that we need, and we're very pleased with that. What will it mean for the firms, and what will they have to provide us with? And we recognise that in order to understand the firms, we need to get more information about them. So we'll be asking them for details, for example, about their governance and structures, their controls and supervision. And that can include details about any bespoke operations, procedures, or practices that they might have. And it's not just about us getting that information from firms, but about what the firm wants to bring to the table. They might have issues that they want to raise, risks that they want to have discussed. So we'll be asking firms to bring things to the table, not just a question of us coming in and asking for information from them. And that will give us a better view of what the risks are within that firm. Inevitably, all of this will take time and commitment, both from ourselves and from the firms. We're not going to be prescriptive about what each firm should provide, and a lot of that will be driven by the shape and size of the firm and the risks we see within that firm. But in any event, we anticipate that we would have some form of monthly contact with key members of that firm. We are, as I said, into the pilot. We've launched our first wave and are on the cusp of launching our second wave. The running time is from October through to July, and hopefully give us sufficient time to work with the firms to understand how this relationship will actually work. And we've already started that engagement process and have found some really interesting points from the firms that we've met with that perhaps we wouldn't have gathered from a distance if we weren't interacting with them in this way. So we're already learning quite a bit from that pilot first wave. And I'm going to hand you back to David now to look at how a risk register might work within your firm.
Okay, thanks, Akitra. Now, some of you may be familiar with risk registers, others not. This is a very simple model and really just included for illustrative purposes. As Akitra said, we are not prescribing a particular way of dealing with it. So I hope this is informative, but please don't think that any work that you do in future necessarily has to follow this format. Let me try to give you some examples and flesh this out a little bit. So if we consider risk A, perhaps a firm might be having difficulties obtaining or anticipates that it may have difficulties obtaining PI renewal. Obviously that's been an issue in many people's minds a month or two ago. So that might be risk A for some firms. And what would the cause be of that? Well, looking at the second column, it could be that a firm has a poor claims or complaints record, or believes that its risk management is not as good as it could be. So if that were the way you filled the register in, you might say the likelihood of the failure to obtain cover would be high or likely, and the impact clearly would be very serious. Obviously, if commercial coverage was not obtained, we'd be looking at the assigned risk pool, and that is obviously not a place anybody really wants to end up. So the overall risk rating high by combining those subjective measures of likely and very serious. So that might be the top of a particular firm's list. Let's think about risk B. Perhaps the risk is increased competition. The cause in the second column might be that there's concern in your particular region or market sector that there will be new low-cost ABS entrants that you find yourself competing with. Likelihood, well, it's all a little bit unclear at the moment. Will they or won't they? Nobody really knows. So you might assign possible against the likelihood. Impact, well, if it does happen, very significant. And by combining possible and significant, you may decide to assign that as an overall risk rating of medium. So you can see the kind of approach, and to start with, if you don't already use a risk register, this will be a fairly subjective exercise. We have been talking to firms who've been using this kind of tool now for 10 years, and it can become more sophisticated and nuanced as time goes by. But what we want to do is to encourage firms to look at the risks they face and understand which are the most significant and why, and what they can do to mitigate or manage those risks. Those are going to be the drivers of a lot of what relationship management will be about. So I hope that helps to clarify some of the phrases we've used if you're not already familiar with that process. Maybe we can move on to look at what will happen after the pilot is finished. Well, I think the first thing to do is to make it clear that we can't be certain. This is a pilot. We don't know for sure how it will work, and therefore we can only use working assumptions. Our working assumption is that the resources available to the SRA will mean that relationship management can only be used with the very highest risks firms. It's not proportionate or is unlikely to be in other circumstances. So given the audience on today's webinar, small firms and sole practitioners, what does that mean for you? Well, we think it's most likely that small firms and sole practitioners, if they have relationship management, it will be because either there is a high likelihood of a risk, a regulatory breach occurring, or possibly because a particular practice is very specialized or niche, and we don't really understand it without relationship management occurring. We think it's less likely that there will be firms relationship managed at the small firm sole practitioner level because of impact. That we think is more likely to be at the global or international city firm end of the spectrum. So what kind of high likelihood issues would we be looking at? Well, it may be we're worried about certain firms because we think they may have difficulties with insurance or be heading towards the ARP. We might consider there a high likelihood of breach where we're dealing with fairly new firms that are just getting going and may need a little bit of guidance and assistance before they become well established. And another thing that we will be looking at is high likelihood of breach because of financial instability. Those are working assumptions, still to be battened down, but that's, I think, the direction of travel. We've talked a little bit about research and preparation. The Risk Centre will work to understand every sector of the market, will collect data, and we will hopefully be able to assess the risk of a particular firm in a particular type of market, and that will become more sophisticated and developed over time. On top of that, the relationship management teams will work with particular sectors. So there will be, if the pilot is successful and this type of supervision goes ahead, there will be a team that looks specifically at sole practitioners or small firms, understands the risk they face, understands the drivers in the market, and they will gather information about these issues, and it will. We hope there will be positive feedback, and their knowledge and ability in the area will grow over time. What will happen in terms of a firm in relationship management? How much contact will there be? How much frequency? Well, that will really depend on the nature of the risks that we're concerned about. It may be that relationship managers go into a firm and are very happy very quickly that the firm is well run, that the risks we had identified as potential dangers have been well managed and mitigated, and therefore it would be inappropriate for us to continue to use a resource-heavy type of supervision. In such cases, it is likely that the firm will move to another type of supervision, desk-based supervision, thematic supervision. There are other tools we're looking at. Where, however, we go into a firm and we are concerned that there are many issues to deal with, relationship management might last for a period of time, and it would be reassessed periodically. So there are different scenarios, and it is not necessarily the case that every firm relationship manager will have a 6 or 8 month period in that type of supervision. A couple more points on the slide. Guidance. We don't expect you to find your way to this type of supervision without some sort of assistance, and in the next 8-9 months we plan to communicate as effectively as possible to help you make the transition towards different forms of supervision. So I guess the message is watch this space. And part of that process is giving you feedback on the pilot. And that may come in 2 or 3 different forms. We will put frequently asked questions and hopefully good answers to them on our website. We plan to give updates on the pilot by email to those who are interested in receiving them, and we envisage that if well received, there may be room for more webinars specifically focused on this issue for your market sector. So that's, I think, all I can say at the moment on that. But what about throwing the floor open for a few questions?
Well, we've been talking, David. People have been sending in their questions, and we've got actually quite a few waiting for us. So thank you for those who've already submitted those. We'll try and pick some that will show a variety of the questions that have been asked, and try to give you as many answers as we possibly can. Let's have a look what we've got in our pots, David.
Just go.
Let's take this question, which says, what is the SRA doing to assist the firms who are in the ARP? There seems to be very little help, is the question. So it's been very topical, David, the ARP, and we know that we've been doing quite a lot of work in the SRA to look at those firms that are in the ARP and understanding why they're there. Specifically, what are we doing to assist them?
Well, Sakitra, I know that in 1 or 2 cases, I perhaps can't speak for more than that, there has been a trialling of a form of relationship management. Colleagues have gone into firms in the ARP and tried to understand the risks those firms are facing and tried to assess the options available. Unfortunately, firms that have perhaps been in the ARP for well, a month or 2 ago, coming up to 2 years, had obviously had a lot of time to try to bring their situation under control, to find commercial insurance, and in some cases there were not too many options available. But there were several cases in which firms were able, with some guidance and assistance from the SRA, either to successfully merge with other businesses or in 1 or 2 cases to obtain commercial insurance and remove themselves. So it's not all a black picture, and we learnt a lot from the process this year. But there are still things to do better and to get right, but we were pleased with, in general, with how that went.
And just picking up on what you said, David, the other thought that has just come to my mind is that actually, if firms are having difficulties, this is the time to come to us and talk to us and be proactive in saying what those issues are within the firm, so that you can get that help earlier. I'm not saying that we will always have the answer, but we can certainly be in a better position to assist you if you can engage with us earlier. So we hope that helps answer that question. We have another question lined up there, David. Will the SRA prepare and circulate model risk registers? And this is something we have debated quite a lot.
Yes, I think my view to start with is that we're very pleased to talk to people about different types of register that we've seen. We're a little bit wary to start with about giving a precedent and setting a model, because we really want firms to find out what works best for them, to make the journey of looking at their risks and recording them in a way that is suitable for their practice. So we're not averse to giving a bit of a help, but I don't think, personally speaking, I'd like to set an absolute precedent.
I think you're absolutely right, David, and that goes also in line with our view of outcome-focused regulation, that in fact the firm has to do that assessment in a way that best suits them to identify their own risks, and we don't want to be descriptive about how that is done, but would be willing to interact with firms to understand where it could be improved if that was at all possible. We hope that that has answered that question for you.
I'm looking at a question now which says, how do you identify a high-risk firm? Well, I think we were trying to give a little bit of a steer to that in the presentation, and it comes about in various ways. I think the main driver is going to start with to be an analysis by our risk centre of a particular firm type. That is a bit of a generality, but within having used that as a starting point, we will look at a firm and see whether we have records of high levels of complaints or problems, and that will adjust our assessment of a firm. There may be positive factors that move our assessment in a different direction. It's difficult to be more precise about this at the moment, because part of the pilot is to work out how the risk assessment and processing goes. So it will start out as being fairly general, but move to be a more sophisticated and targeted assessment.
I think that's absolutely right, David. Thank you for taking the time to answer that one. While you've been busy answering that question, I've been busy scrolling through the many questions that are coming through, which is fantastic. And I have a really interesting question here, which is, we went to a risk management training course recently, and we're told that the SRA can be extremely aggressive when they visit a practice, finding fault with almost everything. How will relationship management differ from what exists at the moment? It's a very interesting question, and I'd like to take that, if I may, David. I'm sorry to hear that somebody was saying that the SRA can be extremely aggressive, and perhaps there are times when that's necessary, for example, where there's a risk of client money being taken. But I don't think that is common practice within the SRA. In many other visits, for example, PSU visits tend not to have that flavour. Perhaps they have in the past, but my experience has not been that. How will relationship management differ from that? That's an excellent question, because what we are saying with outcome-focused regulation, with principle-based regulation, is that we need to have an adult-to-adult relationship with firms. We need to be able to trust you to undertake your role within the firm and to comply with your regulatory requirements in a grown-up way. And if you are able to do that and demonstrate that you are doing that, we should be able to leave you to carry on to do that and focus our resources on those firms that are actually the riskiest. So to test that in relationship management specifically, we are asking firms to bring this information to the table and working with them to understand what those issues might be. And rather than pointing fingers and telling them off for being aggressive, we are going to work with them to say, actually, we don't quite understand how you've come to this conclusion, and be challenging where required, but not necessarily aggressive. It also links to our enforcement strategy, which we published with our April consultation paper, which sets out that how we will work with firms who are willing to work and get things right, and how we will work with those firms who are perhaps less willing to work with us to put things right. So the enforcement strategy does also set out how we want to approach issues, and I hope that you'll see a significant difference in how relationship management works.
Without wanting to just focus on this question, can I add something from a slightly different angle? We have already had one or two firms come to us with particular issues. They're not in the pilot. We've had 2 or 3 self-reports. We've had a firm who's come to us to discuss a particular topic which is an emerging issue. And in those, particularly with the self-reports, we have been able to be very focused. We have gained confidence that the firm is dealing with the particular problems in a very reasonable way, and therefore there's no question of being aggressive. We've seen a sense of cooperation and to sort the problem out. So I share Sakisha's view that it's very unfortunate that aggressiveness has come to the fore in the past, and we want to move away from that. I spotted a couple of questions that I'd just like to pick up on. How many firms are being supervised under the pilot, and is it too late to join the pilot scheme? The plan is at the moment to have 18 to 20 firms. We may have covered that off in the presentation. We've already got 6 up and running, another 6 or 7 shortly to be announced. There have already been 50 firms or perhaps slightly more who've expressed an interest. We are doing our best to find ways of working with firms who want to have some relationship with us, but not everybody can be in the pilot. Is it too late to apply? No. There are still going to be 4, 5, 6 slots left for the pilot at least in the forthcoming week. So if you're interested and feel that you have a firm or a practice that may be of interest to us, please get in touch.
Thank you, David. There's another question that's come in about documenting and registers, and I'm assuming this is from a sole practitioner because the question says, what is the advantage of documenting these matters for a one-man firm? And that's a very good question, because there may not be any real benefit, because the one person in the firm who needs to know it does know it. And we're not being prescriptive by saying that you need to have documents or registers written up, but it may help from a continuation point if you need to be away for any period of time. Is there somebody who needs to step in for you, who needs to pick up things? Perhaps there are some advantages of having some key things recorded, perhaps in cases of your absence.
I think that's right, Sakisha. I'd like to add another point. I went to one of the first pilot firms on Friday, a firm that has been using risk registers for, I think, certainly 8 years, if not 10. And there was a great deal of use to be able to look back over the registers that had been produced over that time, because it was showed how particular risks had been identified and managed and successfully mitigated from a serious or high impact level to a lower way. OFR is all about the ability to demonstrate that certain outcomes have been achieved, and I think moving that to risk registers would mean that even a one-man firm can, if we turned up, could say, look, this is what we've done with the risks, and this is how we've moved on. I think we may have possibly 1 or 2 people waiting for oral questions. Can you tell us if that's the case, Steve?
Okay, if you wish to submit a question via the phone, you can press *1 on your telephone keypad and wait for your name to be announced. At this time, there are no phone questions. However, please stand by.
Okay, thank you for that, Steve. We can continue. We've got a few questions around Lexel. One of them says, my firm is currently working towards Lexel. Should we continue at present, or are things going to change? Another question is, how does this proposed approach interact with Lexel? So a few questions around Lexel there, David. Should we take those?
Yes, this is something we've been asked before, and we think Lexel and quality standards of that sort are an excellent way for firms to improve their systems and risk management by carefully analysing and changing the way they do things. There's no specific tie-up between Lexel accreditation and the approach we're taking at the moment, but we have been asked, and I think we will consider taking a positive view and possibly amending our assessment of a firm because of Lexel accreditation. Does that cover the points that we've been asked?
I think so, David. Certainly, if you've got Lexel or you're working towards Lexel, it will stand you in good stead in terms of having systems and procedures in place for good supervision and control. So it's certainly something that firms should be looking at in terms of quality marks, if that is something that works for you.
There's one question down here saying, is it likely that relationship management will help to reduce PII premiums? Well, I think the best people to ask that are your brokers and your insurers. I know that some insurers and brokers have encouraged firms to look closely at risk management and produce risk registers. So if you are able to demonstrate how you are dealing with these matters and demonstrate positive changes you have taken as a response, I can only think that would be an advantage, but I can't translate that into anything further, I'm afraid.
Okay. Shall we continue taking these questions, David?
Are there any oral questions pending?
There are no oral questions at this time.
Okay, let's carry on with the emails.
Quite a few for us to pick. It's great that so many of you have some questions. Let's just scroll down here and have a look at what else we...
There was an interesting one. We have, for those of you who can't see this, which is everyone tuning in, we have a lot of questions here, and we're just trying to pick ones which we think are maybe helpful. There's one that says, does the SRA consider the impact it has on the time of small practitioners? And asking whether we can in some way ease up in the current economic climate. Well, I understand that in the current circumstances, many practitioners are faced with, well, I've already mentioned, concerns about renewal, possible loss of public-funded work, competition from new types of business, and let alone just doing the work that you have been asked to do to a high quality by your clients. So we are aware of this, and one of the reasons for moving to outcomes-focused regulation is to simplify the rules. We want to make regulation easier based on principles rather than prescriptive, detailed rules, and I think that has to be in a sole practitioner's interest. As regards the time we're asking you to put into our requirements, one of the other things coming down the line is a new way of submitting information to the SRA, which will be an aggregative or a cumulative process. So hopefully you won't have to each year repeat some of the things that you've told us the year before. That's one practical way that we will help you cut down on the time you have to spend. And relationship management or other types of supervision are going to be focused on where the risks are. So if you have a well-run, low-risk practice, then we will try very hard not to cause you unnecessary loss of time or effort. I hope that's some comfort.
Also, just to add that we are very mindful of impact, both on small firms but on the profession as a whole. And because of that, we're looking at many different types of impact assessments, including equality impact assessment, we're looking at human rights, we're looking at cost-benefit assessment. So all of these things are being considered by the SRA because we are very mindful of the impact that it's going to have on practitioners across the piece. And we will be publishing our findings and certainly taking steps to mitigate against anything that is going to be of significant impact. So the SRA is mindful of that, and I hope that gives you some reassurance of that.
I'm going away from to a very practical question now. Somebody's asked, how do we get in touch to make an application, as it's impossible to respond to the email I received? Well, it's a very practical question. At the end of the slides, which we'll move on to, you'll find the relationship manager email address. If you want to get in touch, that will be a prime way of doing so, or the contact centre, if you are unable to access that, would direct you to us. So that I hope answers that very practical question.
On another very practical question, somebody's asking us about whether this is going to be available on a podcast.
Well, I'm not sure we're up to podcast, but we're going to make a recording. We are making a recording of this broadcast, which we hope will be available during the course of next week on the Freedom in Practice page of the SRA website.
Okay. We're coming up to about 25 past. I wonder, David, whether we should move on to the final few slides or take another question.
Well, it may be, given what we've just said, if we just move through some of the slides so people can see the relationship manager email address, and we'll try to get the best of one or two more questions and our last slides as best we can. We're just trying to, there we go. So we're going to move on to the next slides. I think we may have covered some of these off already.
I think that we've covered a fair few of those, David.
So let's move on from that. Okay, future communications and engagement with the profession to date. I'm not sure we've covered all of that in detail, but during the course of the last several months, our team has been meeting both on a firm-to-firm basis, individual visits. We have met with interest groups of all sizes and types of market. We continue to do so. This is the first webinar we've undertaken for sole practitioners and small firms, but we have also broadcast something for the larger firms. So that's the type of engagement with the profession, and we also deal with individual inquiries that come into us. So we feel we're getting out and about as much as possible. Plans for the future, Sakitra?
As part of the SRA's engagement policy, we've got more webinars lined up on a variety of different things. So that might be something that firms wish to do if that suits them in terms of their time and availability. We have also done in the past road shows which firms can attend to listen to details of our consultation papers, and we find that to be an excellent way to contact firms and to capture feedback, which can shape the way that the SRA is going to be working. All those are still possible, and we are very keen to continue to engage with the profession, and actually it would be helpful if the profession has a particular preferred method of being contacted. If there are local law societies, for example, that would like us to contact them and to engage with them, we're very keen and pleased to hear about them. So please do contact us. It's not just about us coming to you. You might have some ideas about how we could engage with you more directly, so we're very open to hear from you.
I think if we move to the next slide, I mentioned the email address. If you do need to contact us, either with a particular query or if you're interested in joining the pilot, that's the way to do it. And we will aim to email out to people who have participated today either a list of the sort of frequently asked questions or some link to access them, so that those people who've very kindly contributed questions today but that we've not had time to deal with will be able to get an idea of what our position is on those points. So unless you have anything else to say, Sakitra, I think we'll probably move to wrap up right now.
No, David, I don't have anything further to add, just to say thank you for participating. We hope you found it helpful. We will be circulating some feedback forms. We'd very much appreciate your feedback on this webinar, and perhaps details of what else you might like to hear about in the future.
Good. Well, thank you very much for participating. We hope this will, as I say, will be the first of many webinars. Thank you for your participation, and look forward to engaging with you in the future.
Many thanks.